Good morning, this is your Kelso Report for Thursday, April 19th, and I'm your host, Clark Kelso. Today we have cases involving patent law, civil rights, criminal sentencing, habeas corpus, an anti-SLAPP case, summary judgment, and criminal sentencing. We begin with the United States Supreme Court, which had an interesting patent law case again today. This time a unanimous opinion by Justice Thomas. Under the Patent Act of 1952, if a Patent and Trade Office examiner denies a patent application, the applicant may file an administrative appeal with the PTO's Board of Patent Appeals and Interferences. If the board also denies the application, the applicant may appeal directly to the Court of Appeals for the Federal Circuit, or, alternatively, may file a civil action against the PTO director under Section 145. The District Court in Capos v. Hyatt held in a Section 145 proceeding that the applicant could not introduce new evidence and that the deferential substantial evidence standard from the Administrative Procedure Act applied. The Federal Circuit, in an in-bank decision, reversed the District Court, holding that new evidence could indeed be introduced in a Section 145 proceeding, and that when such new evidence is introduced, the trial court must make de novo findings of fact as appropriate to take into account the new evidence. The Supreme Court granted review and unanimously affirmed the Federal Circuit. Nothing in Section 145 suggested that there were any limitations upon the evidence which could be introduced. Instead, the section created an independent, quote, remedy by civil action against the director, close quote. Section 145 did not contain any of the limiting language usually found in statutes creating limited judicial review of agency action. For these reasons, the court held that the applicant could introduce new evidence and that the district court had the obligation to enter new fact findings as necessary. In other words, this was not ordinary administrative review. It was a new civil action. Well, next, the Supreme Court had a case under the Torture Victim Protection Act. The Torture Victim Protection Act of 1991 authorizes a cause of action against, quote, an individual, close quote, for acts of torture and extrajudicial killing committed under authority or color of law of any foreign nation. The plaintiff, relatives of one Azam Rahim, sued the Palestinian Authority and the Palestine Liberation Organization, alleging that the Authority and or the PLO tortured and killed Azam while he was visiting the West Bank. Resolving a split of a lower court authority, the Supreme Court held that the word individual in the statute was properly interpreted as meaning only natural persons, and that the Torture Victim Protection Act therefore does not impose liability against organizations. The court affirmed the district court's decision dismissing the action. Next, we turn to the Ninth Circuit and start off with a criminal sentencing case. The defendant in United States v. Austin was sentenced to a 17-year prison term pursuant to a plea agreement where a defendant pled guilty to drug possession with intent to distribute. 2 years later, the defendant filed a motion to reduce his sentence under 18 U.S.C. Section 3582 because the Sentencing Commission had reduced the sentencing range for the drug crime to which the defendant had pled guilty. That was a motion which the district court granted. While the case was pending, the United States Supreme Court decided last year Freeman v. United States, which changed the rules about which sentences could be reduced under Section 3582. Applying Justice Sotomayor's concurrence in Freeman, the Ninth Circuit held that because the defendant's plea agreement was a Federal Rule of Criminal Procedure 11C plea agreement, and the sentence was based on that plea agreement and not based on a sentencing range that was subsequently lowered by the Sentencing Commission, the district court lacked jurisdiction to reduce the defendant's sentence. When the sentence is based on the plea, you're stuck with your sentence. Next, we have a habeas corpus decision from the Ninth Circuit. Under the Anti-Terrorism and Effective Death Penalty Act, there is a 1-year statute of limitations for the filing of federal habeas corpus petitions. The statute's time runs from the date on which the state judgment of conviction becomes final, and the statute is tolled so long as a properly filed application for habeas corpus is pending in state court. When a California state court denies a habeas petition with citations to Ex parte Swain and/or People v. Duvall, two state Supreme Court cases, the question arises whether the denial is because the petition was not timely filed, or whether the denial is on the merits. If the denial is for lack of timeliness, the federal statute is not tolled. Well, in Cross v. Sisto, the Ninth Circuit reiterated its prior ruling that dismissals based on Ex parte Swain and People v. Duvall are not dismissals for untimeliness, and are instead dismissals on the merits. Because the district court in Cross misinterpreted the basis for the state court dismissals, the Ninth Circuit reversed the district court's dismissal and remanded for reconsideration of the habeas petition on its merits. Next, we have an anti-SLAPP case. In Donovan v. Dan Murphy Foundation, the plaintiff filed suit against the directors of a foundation, alleging that he had been illegally removed from the foundation board. His removal came after a series of disagreements and disputes among the directors about corporate governance and financial oversight. The defendants filed an anti-SLAPP motion, which the Superior Court granted. The Second District reversed. The first prong of the anti-SLAPP analysis asks whether the acts out of which the complaint arose were, quote, acts in furtherance of a person's right of petition or free speech under the United States or California Constitution in connection with a public issue, close quote. Well, the Second District held that the disagreements and disputes about governance and oversight of a private foundation were not acts in furtherance of free speech or the right to petition, and therefore the anti-SLAPP statute did not apply. According to the Second District, the board's vote to remove the plaintiff as a board member was not the exercise of free speech or petition rights, and the nonprofit board meeting did not qualify as an official proceeding authorized by law, and that his removal did not involve a matter of public concern. Not everything gets turned into a basis for an anti-SLAPP motion. Next, a simple summary judgment case. The city attorneys of Los Angeles and Culver City brought actions for permanent injunctive relief against the defendant to shut down his commercial marijuana operation. The plaintiffs produced sufficient admissible evidence to meet their initial burden of demonstrating violations of the narcotics abatement law, the public nuisance law, and the unfair competition law for summary judgment purposes. The defendant did not present any admissible evidence to show that any tribal issue of material fact existed, or that he was entitled to any defense, including any defense under the Compassionate Use Act or the Medical Marijuana Program Act. So as a result, in People v. Joseph, the Second District affirmed a summary judgment against the defendant, as well as the entry of a permanent injunction. Next, criminal sentencing. In recent years, the legislature has made several changes to the way custody and conduct credits are calculated. In 2011, the legislature amended the relevant statute to grant pre-sentence conduct credits in accordance with a more favorable formula to enumerated classes of prisoners who were previously denied those credits under prior versions of the statute. The statute itself provided that the amendment operated prospectively only to prisoners who committed their crimes on or after October 1, 2011. The defendant in People v. Borg, whose crime was committed before October 1, 2011, challenged the prospective application of the amendment on equal protection grounds. Well, the First District easily found a rational basis for making the change apply prospectively, and the court denied the defendant's equal protection claim. In particular, the state claimed it was trying to balance the needs of public safety against its fiscal problems. And the decision to apply the change prospectively simply reflected the balance of those two competing interests. Well, that's it for today's Kelso Report. Have a great day in the law.